Mr. Pai has already given us a summary of the events and clarified subsequent to their report that a recommendation was made to the governor, and we have that document. We also have the other document, letter from the governor to Mr. Pai, and then the January 25th letter from OPA back to the governor. Okay, everybody clear? Okay, the chair's ready to open it up for questions from the members. Representative De La Cruz.
Thank you, Chairman. Good afternoon, Mike.
Hi, good afternoon.
Thank you for coming here
thank
today.
you.
Mike, we've looked at your report, and evidently it was submitted to the governor and lieutenant governor.
Yes.
Apparently, the governor came back, basically refuting the report that you submitted, and then you replied back saying that the OPA does not necessarily agree with your comments on the findings. Is that correct?
Yes, correct.
The report that we see here today, were there any other reports aside from this, or were there other entities involved in investigating Mr. Buckingham on this Hatch Act violation?
This was the only report from OPA. I believe Mr. Hasselback may know of other agencies that may have looked into the Hatch Act violation.
Oh, okay.
But I have no information on that.
All right. Do you know if the U.S. Office of Special Counsel had undergone a similar investigation or query into the matter?
I personally don't know, but I think Mr. Hasselback might know about that subject.
Okay, because I'm reading this report from the U.S. Office of Special Counsel. Apparently, a lady by the name of Ms. Doramo had inquired and I believe made a complaint, really, to this federal office, and I just wanted to point out that on some of the language here from this report of the Office of Special Counsel, it stated that to determine whether Mr. Buckingham is covered by the Hatch Act, we examine the federal funding received by his employing agencies and his duties, which is the CNMI Attorney General's Office. Examples of these federal grants that the Office of the Attorney General was receiving was: 1, a Violence Against Women Act grant used to prevent and prosecute violence against women. 2 is a Domestic Violence Prosecution Program grant used to prevent and prosecute domestic violence. An Interagency Financial Crimes and Drug Task Force grant. A Juvenile Criminal Prosecution Program grant used to prosecute and prevent juvenile crimes. So several of these grants are being received by our local Attorney General's office from the federal government. And I believe this is the reason why when Ms. Doramo I believe, wrote to the Office of Special Counsel. The Special Counsel basically did some investigations, I would say. It talked about the gathering for Mr. Camacho, and it also found that the allegations Mr. Buckingham did violate the Hatch Act by asking his subordinate employees to attend a partisan political event for one Mr. Camacho, and by using his influence of employing agency to host this political event. And it's quite interesting because it almost mirrors your report, and that's why I wanted to clarify with you whether you were aware of other entities or federal agencies that were doing such an investigative work on this case.
I was not aware that any other agency was investigating it.
Yes, and this was coming from Mariama Liverpool. She's an attorney with the U.S. Office of Special Counsel.
Mm-hmm.
I just wanted to verify with you whether you were aware of that.
Yeah, I was not aware that the U.S. Special Counsel was also looking into the matter.
Okay. Thank you, Mr.
Thank you.
Bye for now. I'll yield for now, Chairman.
Thank you, Rep. Any other members? Vice?
Yes.
Go ahead.
Good afternoon, Mr. Mike.
Hi, good afternoon.
Can you just clarify, you have a report that was done December 13, 2010 on that ethics investigation that was conducted by your office on the former AG Buckingham with regards to the dinner that was held up at the governor's residence. Can you just clarify a little bit about that report? That's the only report that you commissioned or that you have asked that it be compiled or that is put together?
Yes.
I believe as a result of a complaint that was filed to the office.
Yes, that is the only investigation report we prepared.
Okay. So I have a copy of a letter here indicating the response or outlining the response of the governor on the points that were raised in your report. And he did noted his objections to what was submitted, the report that you submitted. Can you just kind of summarize for us very briefly the main points? I mean, what were the areas of grave concern for the governor?
Well, I can't remember the details of the governor's report, but what I recall is he basically disagreed with our findings of fact and disagreed with our interpretations of the law, and therefore disagreed with our conclusions.
And that was contained in your letter, in his letter of January 6, 2011 to you.
Yes.
And then on the 25th of January, same year, you wrote a response to governor's letter. I'm referring to the January 6, 2011 letter. And in the second paragraph of that letter, do you have a copy of that letter?
Not with me, but
yes, Mike.
I can answer your questions.
All right, in the second paragraph of your letter, it says, first and most importantly, we agree with you that the matter is closed and confidential. OPA has fulfilled its constitutional and statutory mandate by issuing its findings and recommendations to you. No further action is contemplated. And then at the end of your letter, you said that at the conclusion of that letter, you said, as stated above, OPA considers this matter closed and it will make no further comments regarding the investigations or its findings and recommendations. Can you just briefly tell the committee what that means?
Yes, when we said it was closed, it was more of an administrative term because we felt that there was no further investigation work to be done on this case. And when we said it would be closed and confidential, the meaning there was that OPA would not circulate any reports on this matter to anyone outside of the parties involved, which was the governor and the Attorney General and OPA. So it was more of an administrative decision not to put further work into a case where we had already done all the investigation that was needed.
And that it will make no further comments regarding the investigation or its findings and recommendations.
Yes.
So, no further action will be taken?
Yes.
Is that what it means?
Yes, no further action would be taken as far as investigating that case or trying to argue with the governor on the investigation report.
All right. So, just clarify for the committee, is there another investigation that is being done now? And where does this come in terms of this report relative to your letter?
Yeah, we haven't opened another investigation into this Hatch Act violation. So there's going to be no further report on this meet and greet for the political candidate. I don't know if I got the question right.
No further investigation and no further action?
Yeah, there's no further investigation because the investigation is complete. But I think are you referring to the penal summons?
I think it can also include that. Whatever action is further taken, is taken further on this.
Well, the charges of violations of the Hatch Act were included in a penal summons that was handled by Mr. Hasselback, because there were further misbehaviors on the part of the Attorney General, and so I think Mr. Hasselback will better able answer the question why it was put into the penal summons, but I think it was because of the further misbehaviors of the AG that came to light, and so it was decided to include that as part of the charges against him.
So this letter you're saying that your letter of January 6th, 25th, does not preclude any subsequent action?
No, it doesn't, because law enforcement agencies routinely close files but reopen them later on when circumstances change or new facts come to light.
I will yield for now. Thank you.
Thank you, Vice Representative Torres.
I call it back.
Yes, thank you.
Mike, did you authorize Mr. Hasselbach to revive the issue or the case?
Well, what happened was after the January 25th, 2011 letter, I recused myself from the Buckingham case because of the untrue but perceived allegations that I was somehow biased or was retaliating against Mr. Buckingham. So I delegated the Buckingham matters to Mr. Hasselback.
Is there a document that you authorized that delegation?
I believe there is a document that I...
Can we have a copy that you signed delegating him? Because I think that the OPA has a form on that.
Has a...
I think your office has that form that you have to sign delegating him or authorizing him.
Yes.
To revive or reactivate the case.
Yes.
Would you provide that committee, that document, please?
Okay, I will.
Thank you.
Ready? Are you finished? Thank you. Mr. Pai, thank you again for appearing before this body. Let me read the governor's letter to you. On page 2, it says the second paragraph of your December 13, 2010 letter to me and the Lieutenant Governor states that based on the findings of the report, OPA concludes that the AG's actions violated criminal prohibitions of both the Ethics Act and the Election Act. Contrary to this representation, OPA's investigative report does not contain any specific factual findings which warrant or justify the conclusion. Similarly, neither the report nor your letter contains any analysis or discussions of the statutes OPA contends were violated and how certain specific facts demonstrate a violation of law. The absence of a thorough investigation, not making specific factual findings, and the omission of any analysis of the applicable law suggests the conclusions were preordained and the investigation was merely a perfunctory step to reach the desired result. Now, I have your letter of January 25th, which responds to this letter, basically saying you do not necessarily agree with their findings. Mr. Pai, we all have a copy of the investigative report, and there are, in the cover letter, you do state or reference the specific Commonwealth Ethics Code and the Commonwealth Election Act and code, specific codes.
Yes.
And in your findings, I'm seeing, especially in the emails, some of the emails I can read and conclude that it may be a violation of a specific act, but you do not make that reference there. You just provide the evidence. And one of them, just to maybe ask you to confirm, maybe a violation of 6 CMC 6705, which is using the name of a government agency or department to campaign for a candidate for public office. And let me just read it and see if you agree with my conclusions. The email is on August 28. It was an email from F. Dimapan to OAG staff assigned to the Criminal Division, dated August 19, with the subject August 28, 2010 gathering for Joe Camacho. And it says, I am taking this upon myself to inform you all that our Attorney General Edward Buckingham and the Office of the Attorney General as a whole will be hosting a gathering for Joe Camacho on Saturday, August 28, starting at 4 p.m. at the Governor's House. As our AG has said, this gathering is not mandatory, but it would be nice to see our attorneys and staff come and enjoy food, drinks, and view, and be able to socialize with other people throughout the night while this gathering is ongoing. And I read this that because the email uses the Attorney General's name and the office, that is the evidence to support the violation of 6 CMC 6705. Is that correct?
Yes, correct.
Mike, I'm good, but not that good to be able to interpret all of it and be able to place which violation it or what it violated. And I was gonna ask you to place each evidence with place it with which violation, but I don't know if we'll have enough time. I think the emails that were provided do show several things. One, that Mr. Buckingham did authorize Ms. Dimapan to inform the members that this is going to be hosted by himself and the office. Second, that the employee did use the office equipment to disseminate that information. And I think Ms. Frida did, I think in one of her emails, say that she kind of was concerned that she knew it wasn't right. But that she went on to do it anyway, as she was just following the instructions by her boss. Those are basically the two issues, right? Which issue here is relevant to the violation of the Election Act?
Well, I think it has to do with using government resources and government time
I see.
for political purposes.
I see. What I've just stated. I see.
Yes.
Thank you. So I'm just trying to understand their objection to your report or your conclusion. Was it because you didn't say, well, this email is factual evidence that violates this CMC, this code? Is that how they, I mean, I don't know. Do you understand what they're...
I don't understand their reasoning for what they wrote, and I think it would be better for an attorney like Mr. Hasselback to try and interpret that. But as a person not being an attorney, I read it and I disagree with their logic, because I think the OPA's investigation report is based on fact that can be traced to documentary evidence. And when you apply the law to those facts, our conclusions in our report that the Attorney General did violate laws is supported by the evidence.
Thank you. One or two more before I turn it over to the members. But we all know, I mean, after reading the report, I've come to conclude, no, not conclude, but something I did see was that even the Attorney General was asked. He didn't come up with this as his willingness to host. He was basically asked during that luncheon meeting at World Resort, and there was an email correspondence to that effect where, let me read it so I don't misstate it. It says, FDM upon stated that the Attorney General told her that the Governor announced to the Cabinet that the Attorney General would be hosting a gathering for Joe Camacho. So it wasn't really Mr. Buckingham's idea. He was just asked, and I think out of courtesy he accepted. And there's nothing necessarily wrong with that, being asked to host, right? I mean, it happens. I think what's wrong here, the violations occurred when they use government resources to prepare for that hosting. Is that a fair statement?
Yes, that's my understanding too.
Okay. And that further, he uses the name of the, his title, I guess, as Attorney General and the office to invite his staff. And that's basically what this violation is. It's really a very simple violation. I mean, not simple, but it doesn't extend beyond that. We're not, but, we do have a case where the Attorney General, who's the highest law enforcement official in the Commonwealth, who should have been aware that of those laws, and even though he was aware, still instructed his staff to do it. I think that's where perhaps a lapse in judgment occurred.
Yes.
I yield for now.
Mr. Chairman.
Yeah. Vice, go ahead.
I still want to go back, Mr. Pai, to your January 25th letter, 2011. When you say no further action is contemplated, yet, you have been pointing out that the AG has violated provisions of the law, it's very troubling. You can, when I read that, it can mean two things. One is that no further action is needed, meaning everything is okay. The second one is, and you're telling me that administratively, that your office just stops, the work of your office stops right there, and so where do we go? So can you please just clarify what exactly does that paragraph mean? Because, I feel that we need to know.
Well,
because right now you said that the matter is closed, no further action is contemplated. Matter is closed and confidential, no further action is contemplated. Yet, all of a sudden we are faced with a summon.
Mm-hmm. Well, this is what happened. We received complaints against Mr. Buckingham for hosting a political candidate activity. We did our investigation. We prepared an investigation report with our recommendations for discipline to the governor. The governor argued back and basically didn't take any disciplinary action against the AG. And at the time we were considering further action, one of which would be prosecution of the AG at that time. But at that time we felt the cost to the taxpayer of prosecuting the AG would outweigh the benefits, and we were hoping that the governor would take disciplinary action as recommended in the investigation report. Since the governor never did take action, and since the Attorney General continued to misbehave, that's when, by then I was recused from the Buckingham matters, and that's when our legal counsel, Mr. Hasselback, decided to include this Hatch Act violations in his charges against the AG.
So who gives that authority? Is there something in writing? I guess you're going to provide us with a document that says that Mr. Hasselback is now going to move forward with whatever action your office is going to take?
Yes.
And you have that in writing?
Yes.
Did he do that as an acting AG? I mean, acting PA, public auditor, or in what capacity did he do that?
Yes, he was the acting public auditor on matters involving Mr. Buckingham.
And how did that delegation of authority, I mean, that delegation of authority came directly from you?
Yes.
Under the Constitution, that is allowable?
I believe so, yes.
Thank you. How are you to Representative Torres?
I'll recognize Representative Torres. Go ahead, Chair. Oh. Representative Tebtet.
Thank you, Mr. Chairman. I'm going to try to go along the line with the Vice Speaker because I think I'm going to try to agree with her, at least from my perspective, in understanding your points, from my perspective of what you presented. Because, going back to what the Vice Speaker was saying and all these steps that's been taken, there is a complaint, and you also elaborated the process that transpired as a result. Now we also have this article in front of us. First, there's that complaint, you investigate, then you provide recommendation, and those recommendations normally goes to a body, and that's the executive branch. Is that the only?
In the case of a person like the Attorney General, it goes to the governor.
Okay, so in the case of the Attorney General, you recommend, and then we got a response from the administration or the executive branch saying that they are only ordained and not investigating. They were not doing their investigation thoroughly. In other words, your investigation is bad. Are we in agreement with that?
Yes, that's basically what he said.
And then after that, because now you have other information that are provided after those, at least those few steps, then you weigh the cost, as you mentioned, over the benefit with respect to the recommendation. Am I in line with that thought of what had transpired?
Yeah, just because we said that the matter is closed doesn't mean we can't reopen it again.
I'm just saying that's the recommendation, that what you've investigated, recommend to the administrator, to the executive branch, and then they take it from there.
Yeah, we would have hoped that disciplinary action would have been taken by the governor.
It didn't.
But he did not take any action.
It didn't happen, and so I'm trying to align my thought with the Vice Speaker. So you have the authority to investigate. Do you have the authority to prosecute?
We cannot prosecute, but we have a provision in the statutes where we can hire a special prosecutor.
And that's where we are at this point because of the charges now in front of the court?
I think so, but for a more definitive answer, it would be better for Mr. Hasselback to answer that.
I'll hold with that. And then you have some of the concern on the lack of thorough investigation and factual finding as submitted to you in response to your letter from the administration, and that because of your, I guess I'm going to use style in doing the investigation. Did you subpoena those necessary documents that would help you with your final recommendation?
Yes, I disagree with the governor because we did do a thorough investigation, and we have very professional and very experienced investigators who conducted all the field work.
I'm going to be very specific. On page 2 of the letter from the governor, it says the second paragraph. Within the mid part of the second paragraph, it said the Ethics Act vests OPA with power to subpoena non-government officials and employees. We're in agreement with that? So were you able to subpoena non-government or any documents so that it assists the investigation in maybe coming up and to finalize your recommendation as such?
Yes, I don't recall us having to subpoena anyone because we got full cooperation from the people.
And it went further to allude to some of those provisions within the law that authorizes you to promulgate your regulations, that I think it says that the website identifies certain conduct that it deems prohibited.
Yeah.
I guess my question is that are these regulations adopted?
Yeah, they're all from the statutes.
At least from my reading with this page 2 last paragraph on to the next page in page 3, from my comprehension of this statement, it's saying that no, it's not been adopted. Let me read the last sentence in page 3 of this. It says these provisions, and it enumerated up to 9. These provisions on OPA's website are not rules contemplated by subsection 8534C. And they are not, as they are not promulgated pursuant to Administrative Procedures Act. That's what.
I think what's on our website is supposedly all from the statutes.
Okay. It went further to illustrate, in this sense, I said, for instance, although OPA, the violations that you've on the Attorney General, you did not identify or point out any specific fact or facts with which substantiates that the AG personally used public funds, time, personnel, and equipment for political or campaign activities. We're in agreement with that?
I disagree with the governor's statement on that because I think our investigation report did have documentary evidence showing that government resources were used for political purposes.
Okay. Thank you very much, Mr. Pan.
Thank you.
Anyone else? Representative De La Cruz?
Thank you, Chair. Mike, relevant to Rep. Tabutep's statements and his read on the governor's letter, what would constitute a use of government property with regards to this case? Can an email correspondence, let's say between one government employee and another government employee, speaking of a meet and greet, if you will, on government time, in this case for the Attorney General, through your investigations, were there evidence found that a certain government employee during government time was corresponding via email to another government employee? Was that one of the findings that OPA had?
That's one of the evidence that we have in the various attachments to the investigation report.
Okay, so the answer is yes.
Yes.
I guess it makes sense for one government employee on government time corresponding to another, sending off an email with regards to a function of this type, and of course the subject being the Attorney General hosting such an event would, I guess, constitute an illegal act, if you
Yes.
will. Okay.
Yes.
Okay. I'll yield for now, Chair.
Thank you. Mike, did you respond to Mr. Buckingham's letter to you dated hold on. One second. It was I'm not sure if it was an email or letter from the Attorney General to you, but it was basically responding, I guess, to your either your email or your, just a moment please. Oh, I find it, attachment 1. Thank you. It's a memo from the AG to you, and was on September 7, 2010, and in it he acknowledges receipt of your September 3rd letter. Sent Friday, September 3rd at 4:27. It says, please be advised that no illegal campaign activities have occurred. What did happen was, the first, a dinner at the governor's residence began as an idea for me, the governor, and our wives to have dinner at the governor's house. It says, later, the idea moved to having a gathering at the governor's residence, adding members of the AGO, attorney, staff, family, and friends. And then he goes on to say, later still, adding Joe Camacho as a guest and providing an opportunity for him to speak to the gathering. And he attached materials responsive to this issue. He says, I trust these materials will resolve the inquiry. However, this should this proceed forward, please also find attached a summary of issues concerning case management. The case management document includes issues that I request be addressed. First, we haven't seen the materials that he provided. You have. I guess my first question is the information that he wrote or that he gave you here about it starting as an idea with the governor and, you know, I guess growing from there. Do you agree with that?
Well, I don't recall, and I don't think I responded to that memo. I gave that memo to the investigation units for their disposition as part of their field work. But you know, I don't. Looking at it now with all the evidence, I don't think I agree with his statement.
And why would that be?
Because I think the documentary evidence that was obtained in our investigation shows that it didn't it didn't happen like that.
Thank you, Mike. Representative Torres.
I think Mr. Pai responded to the Attorney General, former Attorney General, by attaching all this attachment in the OPA report of investigation. Do you agree?
Well, I don't see a response. I don't see a response. I do have the various exhibits and emails and so forth, but I think that came with the report.
Yes.
And the report was dated December 13th, so it was much later. Just, I wonder if you recall, what did your letter of September 3rd say that it says regarding your letter of September 3rd, 2010, criminal and ethical violation investigation?
I believe that letter is our standard letter that, notifying a person of, like in the Attorney General's position, that he is under investigation and the nature of the investigation.
So this would have been the first, Ed's memo to you was the first official acknowledgement by him that an OPA is conducting an investigation.
Yes, I believe our September 3rd letter was a standard letter notifying a person in his position that he's under investigation.
Vice?
Yes, Mike, just so that we can understand the process a little bit more, can you just go through what the process is that you follow when an investigation is asked or a complaint is filed, in particular, especially with this case, but normally what would you do? What is the process that we go through?
When we receive a complaint involving an elected official or an appointed official, we notify them in writing that they are under investigation and the nature of the investigation. And then we conduct our field work. When the investigation field work is complete, we prepare an investigation report. In the case of an elected official or appointed official, the report goes to that person's supervisor, which in the Attorney General's case was the governor.
So the process stops there.
It's our part is stop there, but the person's supervisor should take further action.
I see. Okay. Are you for now?
Any other members? Representative Torres?
I still say that the OPA responded to Buckingham's memo on September 2nd by conducting an investigation in Buckingham, thereon delivering the report, Mr. Pai's letter covering that report, and even copying to CC Edward Tibakin, Attorney General. That's a response to him by that simple mail. Right?
Could you
3 months later, eh?
a response 3 months later? But that doesn't make sense. That oh, well, the timeline doesn't fit because it was September 7 that Mr. Buckingham responded to Mr. Pai, referencing Mr. Pai's letter of September 3rd. And so, on September 3rd, Mr. Pai informed Mr. Buckingham that an investigation is already underway, has already been initiated. And so, I don't know, the timeline doesn't match. Mr. Pai, do you have a timeline here, a sequence of events with
I don't have a timeline with me, but I think a person who's closer to the details like Mr. Hasselback would gladly provide that.
members? Do you have anything else? I think most of the questions we're asking are more relevant if they're posed to Mr. Hasselback.
Just one last. Mike, since you are the immediate supervisor of Mr. Hasselback,
Yes.
when did your office hire him?
He came on board at OPA in February.
Of this year,
Yes.
2012. And
Yes.
what is his exact position title?
He's legal counsel.
Legal counsel for the Public Auditor's Office?
Yes.
I said it's the last one, Mr. Chairman, but this is going to be the last one. You mentioned earlier, Mike, that your office does not prosecute. What does that mean?
We do not have prosecution powers.
So you would be relying on the AG's office to prosecute, or outside of your office?
Normally, we would rely on the Attorney General's office to prosecute our cases, but in the case of an official like the Attorney General, then we would have the power under the statutes to hire a special prosecutor.
A special prosecutor.
Yes.
So what role did Mr. Hasselback take in this particular case when we will be posing the same question to him, but what role did he take with this, the summon and, the case against Buckingham?
Well, he prepared a document to charge the AG with certain crimes. So it's what we do with the Attorney General's office. We prepare a charging document. We refer to the Attorney General's office for prosecution.
So who's prosecuting this now? I just want to make sure that I understand.
I think it's in the courts now, in Judge Wiseman's court. But I don't. I think you have to ask Mr. Hasselback as to who's going to be the prosecutor.
But it's not your office that's prosecuting.
I have no information.
I just want to make sure that I understand. Thank you very much, Mike.
Thank you.
Mike, just one more thing before we release you. You stated that you appointed Mr. Hasselback to be the acting OPA at one point, and you recused yourself on to you recused yourself, and Mr. Hasselback was to be the OPA for specific investigation, right?
Yes.
You're still the OPA for all intents and purposes, but with regards to the matter of the Attorney General, he would be the acting OPA. Is that a correct statement?
That's correct.
And you mentioned several times that you recused yourself and that charges were later filed by the acting OPA after the Attorney General was, I think the word used was misbehaving.
I use that as a polite way of saying he violated further laws.
Can you clarify? I don't always read the paper, so what does misbehaving mean in this sense, and what violation of laws are you?
The laws, procurement laws concerning the ARRA contract, and then the election and ethics laws on the Hatch Act violations.
I see. That's all, Mike. I don't have anything else. Do the members want to ask any further questions? Thank you. Mike,
Thank you.
I really want to thank you for coming and for being forthcoming.
Thank you, Chairman, and committee members. Thank you.
Thank you. You are dismissed.